Hello, everyone, and welcome to FITC's Legal Basics for Freelance Designers and Developers webcast. This is our first webcast of the kind, and we really hope you enjoy the programming. I'm Carolyn McGregor, and I am here with Rosy Rumpal, the Lean Lawyer. Rosy, welcome.
Hi, Caroline. Thanks so much for having me here today.
I'm so glad that you made it. Can you tell us a little bit about the Lean Lawyer?
Sure. So the Lean Lawyer is my law office. I've recently established it after taking a bit of a break from criminal law litigation, and I was actually away in Vancouver and San Francisco last year, got my feet really wet in Silicon Valley, helping some nonprofits and startups.
Yes.
When I got back last year, I decided to establish the Lean Lawyer Law Office and help as many startups as I could.
Fantastic. And you also act as an advisor at Ryerson's Digital Media Zone.
Yes, both the Digital Media Zone and the Fashion Zone as well.
Fantastic. Well, we're so happy to have you here with us tonight. Rosy is going to do a presentation, and then we're going to follow it with a Q&A. So if you do have any comments or questions, you can leave them on the YouTube page. If you're watching this stream through FITC.ca, you can click on the YouTube icon in the bottom right-hand corner and take you over to the YouTube. Or you can also leave a comment on Twitter at FITC. So Rosy, I'm going to leave it over to you.
Okay, sounds great. Thank you. All right, so legal basics for developers and freelancers. Now, I'm a big fan of Eric Ries's The Lean Startup. So my, opinion of contracts is there's some good opinions and some bad opinions, but we're going to do an overview of contracts, negotiation strategies, copyright, and trademarks, and keeping in mind that this is for anybody who's involved in startups at any level. So moving forward, with a contract, what is actually needed for a contract to exist? Contract has to be some type of a written document. It needs to be signed, and that's pretty much the only two things that are needed for it to be legally binding. Now, various types of contracts have different types of elements, but I'm going to be discussing most of the mandatory elements involved in a contract that you're going to probably come across. And just to keep in mind, a lot of freelancers and developers, designers, whenever they're dealing with some type of client, it is most often that the client is going to be the one presenting them with a contract. So it's really the onus is up to both the designer and the developer to decide and review the contract and basically agree or disagree with the provisions of the contract. So the main elements of a contract are, one, who are the parties involved? And as obvious as this may sound, most importantly, what needs to be mentioned is, who is the client? Are you dealing with an actual business? Are you dealing with an individual? Furthermore, who are the developers involved? Making it clear that the developer is a freelancer or an independent contractor. This obviously applies to graphic designers as well. And also making clear what the relationship is between the parties, that it is not a relationship of a business partnership, a joint venture, or that of the independent contractor being treated as an employee. The next main element of a contract is the service being provided. An actual list of services that are going to be provided by the developer, whether it's a completely responsive website, a web application, a mobile application. And actually, it's really important to create a very detailed list. A lot of people indicate, well, we don't want it to be too detailed because the service is being provided. What's the point of actually having things written, like one page on an entire list? But the more detailed, the better. And with each detail that's there, it's important to probably, at the very least, indicate what the responsibilities of each party are. So for example, initially, especially with developers or designers as well, you're going to look at things like the client has to provide you with a certain amount of content, or that the client has to provide you with some images, and when you expect those responsibilities to be fulfilled. And the same goes for the developer or the designer as well, and what their responsibilities are. Next, we'll look at the next contract provision that's very important, and actually I should bring to your attention that this is probably one of the top disputes, no surprise. Payment terms, we're looking at time and materials versus fixed cost. So in a nutshell, you're looking at either you're getting paid an hourly wage or you're going to get paid a lump sum. The best way to kind of break down payment terms for a contract is when you split up your project into different phases, also known as milestones within the contract. And in terms of just focusing on payment for now, usually the first milestone will be just obtaining the information you need to get started, getting the clients whatever their wants and needs are, and then at that point in time getting an advance retainer. The advance retainer can't be too large. We're not looking at, a couple of $1,000s, but it could be as small as $500 to $2,000. This tends to be the industry standard now, and that is for the purposes of trying to establish some type of credibility and trust with your client. And obviously, they're not going to come up with a very large amount, but it does depend on your client. So having an advance retainer to get started. Furthermore, breaking your contract, or at least the milestones, into key deliverables, which are your project phases, whether it's a significant portion, and then making sure that your client accepts that portion that's completed, and then signing off to move forward. Finally, you've got a final deliverable, which would be upon completion and acceptance, and making sure that you get paid, in full as of that point in time. This element tends to be extremely subjective. You're dealing with a client who not only accepts that the work has been done, but the acceptance is actually subjective in accordance to the client's wants and needs. Are they happy with the final product, or is something actually missing? And this is where you may have to include something along the lines of, are you going to have some type of revision process that you're going to be able to make a few revisions and only then it's considered a final deliverable. In terms of method of payment, make it extremely clear how you would like to be paid. Providing invoices with each milestone is really important. Making sure that you're indicating it's a certified check, draft, Visa, PayPal. These are really good options to use with some of your clients. A lot of people may think, well, is there any point in just working, maybe I should work with what my client has. Well, a lot of the times just being clear that how you would like to get paid is the most important step. So letting them know the deadlines of when you would like to get paid and how you would actually like to get paid. If it's cash, if you are dealing with cash, make sure you provide them with some type of a receipt, and on top of that, an invoice that reflects that money or the balance or the first payment was made in cash, because you always want to make sure you've got some type of paper trail with reference to payment, so that, if your project lasts 6 months and you've got 10 different payments, that you've got complete track of each one. Another really big element in development contracts, freelancer contracts, is that of confidentiality. Clients really want to know that you're not going to be leaking out any of their confidential information during the time of you preparing for the project and completing the work. And at this time, you may actually be asked to prepare some type of, to sign some type of a non-disclosure agreement. I'm not going to get into the details of an NDA right now, but it is highly possible that that will be a provision in the contract. And if you've got an issue with that, then you need to bring it up front. Another really important element is that of competitive and conflicting jobs. I'm beginning to see this more and more. A lot of clients, businesses that are hiring developers or freelancers, make it extremely clear for the duration of the contract, whether it's 6 months or 8 months or even 3 months, you're not allowed to work for any competitors. You're not allowed to take on any conflicting jobs. And sometimes they do throw it in there as well that there may be a limitation period after the actual contract is complete. So, you're not allowed to work for a competitor up until 6 months after the contract has been completed. Now, I think this is something that developers and freelancers really need to, and designers really need to take into account. If you are, freelancing, you don't have control over the types of clients that are going to be approaching you. You don't have control over the types of jobs that you're going to be getting. So if you think that, you've suddenly attended an event and you've got a lot of clients that are from one particular industry, you really need to make sure that this provision is not included in your contract at all, or that you kind of work with the first provision, which is that for the duration of the contract. Now, a lot of these contracts, the crux of everything lies on the intellectual property aspect. So the first question is, especially for developers, I've given an example in my slide here with reference to who owns the code. Now, this can also apply to designers in terms of who actually owns the files, like the CSS files, the HTML files, even the images. So the first question is, that of open source versus your proprietary code. And there's, I guess, two general ways where it can actually fall into place. One is for work for hire contracts, and finally, just basic independent contracts where you still retain your intellectual property. So just giving you a brief, there's a lot to talk about for work for hire contracts, but very briefly, working for hire is like an employee of the company. So this is what Google does. This is what other companies have done. Any work that is done for your client is all owned by the company. All ownership of the intellectual property, whether it be in the form of copyrightable works, ideas, products, background technology, any type of information. It could even be an idea that comes up through your negotiation. All ownership of IP remains with the client. You own nothing and you don't have a right to any of it. Essentially what you're doing is you're giving up your right to reuse code and to maybe even include something in your professional portfolio as well. Further, if there's ever an issue with reference to, copyright infringement, or if you feel that, you suddenly want to use the code with another client, well, by having a work for hire contract, you've given up all of those rights. And essentially, the most important thing is you're waiving all future claims of copyright. It's, thinking of it simply, if you've written an article for a newspaper and you've waived all your rights towards claiming any ownership of that newspaper can use that article in any shape or form, and you have no claim for copyright with that. So same thing applies to designers and developers when it comes to using their own code. You have to be really careful with work for hire contracts. There are two types. I guess there's the preliminary code and then there's the final code that you end up providing for your clients. So making sure if you are stuck in a work for hire contract, perhaps making it clear that you're providing them with the final piece of work as opposed to the preliminary code is where you still retain your IP. Independent contracts, license, and assignment. So essentially what that comes down to is it's not a work for hire contract. You own all of your IP, even partial. It all remains with you, the designer, the developer. You retain those rights to source the code, to keep your code libraries, and to use that type of code with all of your future clients. And essentially what happens is you license or assign the right to your client to use or modify your work as they please. Now there's obviously a lot of different provisions that can come into play here. You can indicate that they have an unlimited right to use. They have a very particular right to only modify your work. And essentially you retain your rights, so you're kind of dictating exactly what the provisions are as of that point in time. How you want them to use it, when you want them to use it, where you want them to use it. So essentially what you're doing is you're granting a license. Do you charge for that? It's totally up to you. It's sometimes common, sometimes not. Everything's on a case-by-case basis. Now moving forward, representations and warranties are also an important part of contract. It's just general contract law. Express warranties, those are basically expressed very directly in a contract. You are indicating that any work that has been done is the original work of the developer. You're also indicating, or the designer, you're also indicating that the work is, you're expressly warranting that the work that you are completing is going to definitely meet the requirements set out in the contract. And furthermore, that there's not going to be any material defects in what you provide them. And there's always going to be minor bugs, whether it's something's missing in a design or there's bugs within the code or within the program. But the main thing is that it's an actual proper working product. Implied warranties come along with, it's a basic implied by law of contract. So you're indicating, at least the implication is there, that you're not infringing the intellectual property of any other third parties. You're making sure that the product is actually made for a specific purpose and that your work is going to be used in a reasonable manner and it is going to be in reasonable working order. So that is with reference to merchantability. There's a few other implied warranties, but that's just to give you an example of contract provisions that you might see in, I guess, the fine print of your contract. Now, there's also going to be an important contract provision with reference to indemnification. So essentially what indemnification is doing is you're indicating that if there's any issues, you're not going to, run after the client to get some damages back. If there's some type of intellectual property claim, or if there's something that's gone wrong with the product, that you are going to take almost all responsibility for whatever's gone wrong or any damages. So essentially what you're doing is, in a client's contract, they're saying that you're going to hold harmless the client against any damage or loss in case of infringements. If the client is found to infringe, then perhaps an indemnity agreement would be that you would contribute to the damages. So if a client is found, to have created some type of problem, or something's not working, or there's some type of issues, that they may want that you contribute to those damages, which essentially means that money is going to come out of your pocket if there is found to be some type of infringement and that you've signed this indemnification agreement. Then there's with reference to proprietary rights indemnity. So essentially, without getting into a lot of detail, because there are a lot of rights around this area and every indemnity clause is a bit different, but essentially what you're saying is that your client's misuse of your IP, you have every right to be indemnified by the client. So if you are found to have made some type of intellectual property infringement, whether it's copyright or trademark, etc., that because it was a product that you made for your client and you did not have anything to do with the actual infringement, that you can then be indemnified, paid by your client for some of those damages. Another provision that's coming up more often is that of insurance. You're looking at, there's some clients out there which really want to make clear that you've got some type of comprehensive general insurance. You can get this pretty much from any company out there. However, I guess the main reason why clients want to do this is because they want to make sure that if something happens, whether you get sick or there's some type of damage, or I don't know, something happens to your laptop while you're creating their product, that you're not going to be going after the company for anything, and that you actually have your own insurance to cover you in case of any type of illness or damage or lawsuit. So insurance is something that a lot of clients do need, or a lot of businesses do need, from their designers or developers as well. It's becoming a bit more mainstream, and the businesses indicate that this is something that just makes the individual look like they actually take their business seriously in the event that anything were to happen. Another important contract provision, and this is key to, I guess, being a little bit more foreshadowing the future in terms of termination. So looking at material obligations, does the client have to pay? What does the developer have to do? If there is some type of failure to produce the product, is there going to be a time limit before you actually terminate the contract? So if a material obligation is not fulfilled in a contract, that can completely terminate a contract. It is possible to indicate, well, that person has not, whether it's the developer, the designer, or it's the client that hasn't come forward with what were the main responsibilities. Definitely a contract can be terminated on those grounds. You may want to throw in a bit of a time limit if there's failure to pay within 30 days or there's failure to come up with some content with 30 days, that the contract is going to be terminated. As of that point in time, you look at things like returning property. Is there a certain amount of money that you have you been retained up front? Maybe you only charge for the services that you've provided. Some contracts would actually have a cancellation fee, but not necessarily. A lot of contracts can also be terminated with cause, so meaning failure to meet a material obligation via written notice. But usually, I guess the best thing to do with due diligence is to have some type of time limit set up before a contract is actually terminated. What some developers have done in the past, it's not so common anymore, but I thought I'd still mention it, are kill switches. So putting something into an app or a web app or a mobile app, which is a function where the developer has access to completely remotely shutting down the app or shutting down the website. And sometimes developers have done this in the past because they weren't paid up front or there's some type of a dispute. And in terms of the industry and where courts are kind of heading, kill switches are not seen favorably in the industry at all, and you're better off just trying to do your best to negotiate some type of a dispute rather than shutting things down completely from their side as a result of one payment. With reference to another provision, if you've got a couple of subcontractors working with you or some type of a student multi-employee provider, this is a contract provision as well that you may see. So all of the designer or developer's employees, subcontractors have to read, understand, and sign the contract. So a lot of individuals and businesses will want to make sure that anybody else who's working with you signs the contract as well. Finally, you've got disclaimers and limitations on liability. These are standard clauses, what you can refer to as the fine print, to limit liability in certain circumstances, and you just have to be really careful with things with reference to damages and possible infringement claims. All right, so moving forward away from contracts, non-disclosure agreements and IP assignment agreements. So non-disclosure agreements are actually contracts and they are enforceable in a court of law. Essentially what you're doing is you're agreeing to not disclose particular information, and this is most often confidential or trade secret information to anybody, unless it's an employee within the company. For example, Apple, this is what they did. I believe Steve Jobs got almost all the employees to sign some type of non-disclosure agreement because there were trade secrets, and anybody that he dealt with, even if it was just through discussions, would always end up signing an NDA as well. You try not to just sign every NDA that comes your way. It's important to get some maybe independent legal advice. That's what the ILA is there for. Read carefully, because of the fact that, it's only a 1 to 2 page contract, but you got to be really careful in terms of the IP that you could be giving away, or, by actually agreeing that you're not going to disclose some information, you may be giving up your right completely to even, sit around with some buddies and ideate over some possible options. So that's something you really need to take into consideration. Sometimes individuals are given actual IP assignment agreements. They look like NDAs, but they're completely not. For startups actually, the founders and co-founders, what essentially IP assignment agreements are assigned, what they do is assign their IP over to the company. So this is something that investors like to know, that all IP belongs to the company and is not being held by 1 or 2 individuals. Now, with reference to developers and designers, sometimes an IP assignment agreement can be disguised as an NDA, but it's not. You need to be careful, because everything, they may be indicating that during some type of discussion, everything you disclose or develop during potential business discussions will be owned by the client. So, if somebody's asked you for a bunch of ideas or some mock-ups or prototypes of some sort, you may want to be really careful that, you're not signing off your right to even have that idea or that right to even try to execute it at another time, because even though nothing happens. So something to keep an eye out for. Essentially, both NDAs and IP assignment agreements should be mutual. So both individuals should be comfortable saying that they don't want to disclose confidential information, so both for the developer and for the client as well. And there's not a very substantive onus on one individual to not disclose some information, and that they're the ones giving up a lot of their rights. Now with contracts, a lot of the times, like I had mentioned earlier, contracts tend to be, a lot of clients already have them pre-drafted. So whenever they meet a freelancer or who's a designer or developer, they've already kind of got a boilerplate prototype of a contract they would like somebody to sign. Now, I think there's a few strategies which can kind of help you out with reference to maybe try to make things go your way, or maybe trying to have the contract be some type of a mutual agreement so you feel like you're not being undervalued. I mean, as simple as it may sound, but just listen. First, when you sit down during that initial consultation, sit down, listen to your client's wants, listen to their needs. It may be that the client has some perceived needs, but by you just sitting down and talking to them, you are able to determine what their actual needs are. And that will put them in a position of trust, because you're actually able to interpret what they need and what they need and what they want as of this time. And next, don't hesitate to educate your client. I think, graphic designers and developers, more often than not, they don't realize and accept that they're really the expert. Your client's coming to you, approaching you because they're the ones who've got a problem, and you're the only one who can solve it. So feel free to educate your client, let them know what types of, what the process is, how you're going to be helping them. Is it going to be, a database? Are you going to be sourcing code, etc.? Giving them all the details that they need to let them know exactly what is entailed, or what entails the actual project, and not making it look like your client doesn't know anything, but just making it clear to your client that you're being upfront and honest with them with reference to what they need and how you're going to go about doing it. Finally, I'd also say another important step is don't sweat the small stuff. I think a lot of people go back and forth during negotiations, talking about really small things that you could probably actually give up. Don't forget, at the end of the day, time is money. So the more you keep going back and forth over little provisions, whether it's, a couple of dollars here or there with your hourly wage, or making sure that you include some type of icon on the website, or etc. I think it's important to just really focus on the big components that you want in your favor and not worrying about the small provisions. Next, I'd say don't reject immediately. A lot of the times clients have some issues, and developers or designers are going to say straight up, all right, listen, I just can't do this. It's not doable. I don't see where this is coming from, and I'm not going to be able to help you out. However, I think it's important to kind of really see where your client's coming from. If there's a particular issue, reframing those issues so that you're actually able to, maybe work something else out with them. And I think finally, just, walking into some type of contract negotiation, knowing your breaking point, right? Knowing when to walk away. You need to understand that, there's only so much that you can actually negotiate to the point where it's going to affect your life. Nobody wants to do work where they feel that they're being undervalued, because it's very simple. If you feel like you're being undervalued, you're not going to be coming up with just as good of a product, and it's not going to be your best work, because you're going to feel that you were undervalued anyway. So why should you put in a little bit of extra effort? So I think knowing your breaking point, when to walk away, is extremely important for you to move forward. Now I'll talk, I've got 2 more slides just with trademarks and copyrights. Now I'll put it out there, I'm nowhere close to being an IP lawyer or a patent agent or a trademark agent, but I've got contacts who have provided me with some information, and I don't assist clients with any type of IP law specifically when it's not involved with contracts. And I refer my clients to another lawyer. So any questions, I'll do my best to answer. But just to give you an overview of trademarks and copyrights, so the Canadian Intellectual Property Office defines trademarks as: a trademark is a word or a combination of words, a design, or a combination of these used to identify the goods or services of one person or an organization. So a patent agent or a trademark agent can register a trademark. Sorry, that should say trademark. So trademark agent registers trademarks. Depends how much what you're actually going to be, how many words or designs you're going to be requesting for filing, but costs can range anywhere between $1,000 to $2,000. And it's also important to note that just by having a domain name does not reserve your trademark rights. So just because you've decided to have the domain I love domains doesn't mean that you can necessarily trademark the words I love domains, because another company could have it, but they just may have a different website. So just by having a particular website name or domain name does not reserve your trademark right. So, I mean, sometimes where does this fall into place for developers and designers? Your clients may ask you, hey, I've just incorporated a company and this is my company. I want it to be ilovedomains.com. And, sure, they've got their incorporation papers, etc., ready to go, but you can always advise them, or you can look it up yourself. A basic rule is when in doubt, check it out. I've provided a link for doing a trademark search, and this is, I think, trademarks from like 1971 are registered with CIPO, and you can have access to all trademarks that have been registered, expired, filed, expunged, etc. So this is a pretty good idea of what trademarks exist out there, and a lot of them are from other countries as well, but it's pretty much the Canadian database. Finally, with copyright means, and this is also from the CIPO website, the right to copy. In general, only the copyright owner, often the creator of the work, is allowed to produce or reproduce the work to permit anyone else to do so. So with reference to, I guess, any work in Canada, there's no official requirement for registration in Canada. Literary works, music, etc., the mere fact that you have created something gives you the right to say that it's copyright work and issue a license for reproduction. Writing code is copyrighted. It's considered a literary work, and you're automatically granted copyright for that. In Canada, it lasts 50 years, and after that, no license is required. So, I mean, if an individual, I give a simple example here for Keep Calm and Carry On. This was a copyrighted phrase somewhere from the UK, and I think 50 years was up just a couple of years ago, and as you can see, everyone's kind of using it to their own discretion, and nobody has issues. Now, if you've got copyright with reference to something, this comes down to not your work for hire agreements, but your other independent contracts. You have the right and the ability, with or without licensing fees or royalties, to kind of move forward and give somebody the right to use your source code, preliminary, final product, and you can even specify, do you want to reuse, if you're going to allow them to reuse it, modify it, share it, redistribute it, and for specific purposes you could throw it in there that they're allowed to do it for reverse engineering purposes, and that's about it. So I think that takes us to the end of our presentation. I was asked to do some legal basics, so I hope that that's basic enough for you. And I mean, if you have any questions, feel free to ask. I'll do my best to answer them. And yeah, thank you for tuning in.
Rosy, thank you so much again for being here with us tonight and giving us a great overview of the legal basics for designers and developers. We do have a few questions that have come in.
Sure.
First off, we have Lynn, who is asking about the contracts. Does it have to be physically signed by the contract? Can it be printed or even an email confirmation for it to be legally binding?
Well, a lot of the times, I mean, it should be technically signed. So, I mean, for a contract to be enforceable in a court of law, I mean, if there's ever any type of dispute, it needs to be written and signed by both parties. Email correspondence, sure, it shows that there's some type of paper trail towards an agreement, but really, if you don't get paid and your contract is worth $10,000, in a court of law, you know, they may be able to say, well, you know, how serious were you about this contract to begin with, because both parties didn't sign off on the agreement.
Right.
And you know, what if there's some type of fraud issues, right? Like, well, that person wasn't the one who actually wrote the email, or there were some misunderstandings. Yeah.
Definitely recommended to get it signed then, even if it's signing back and forth, faxing it, get that signature on it.
Yeah,
and both of you to have a copy of it as well.
Yeah.
Both
definitely. And I have had questions where, well, what if the person has an email signature? Right. Well, at the same time, it's not an actual signature. Like a contract would be.
Anybody can put
absolutely
that there.
Yeah. I mean, contract law is dated in Canada to the point where, I mean, hey, if there's two people sitting in a bar and they decide on a bunch of things, if it's written on a napkin and all the provisions are there and both people sign it, that's a contract.
It's legally binding.
Yeah.
Okay. Good to know that. We also have another question about non-competitive agreements. What is a good time frame or an acceptable time frame for that?
Well, I guess it all depends on a case-by-case basis. I mean, a competitive agreement, I mean, if you're, I don't know, let's think of an example. If you're dealing with a fast food restaurant and you're doing something, you're developing something or designing something for that fast food restaurant, they may be able to say, look, we don't want you to work with any other fast food restaurants for the duration of this contract. Right. And you both should know what the duration is, if it's 6 months or if it's 3 months or a year. Industry standard tends to lean towards the duration of the contract and even 3 to 6 months after
that contract is ended as well.
Yes.
Okay. Yes, I know that's come up a lot that I've seen and I've asked. So so about 3 to 6 months might be a good time frame for it.
Yeah, and I mean, just putting it out there, not every business will have you know, past the duration of the contract. Some businesses are like, as soon as you're done our work, we're absolutely fine. But I mean, it's something to make sure that you
make sure it's clear.
Yes,
either
exactly.
way with it.
Yeah.
Okay, good to know. Also, we had a question about designers and developers who are just starting out. How important is all of this in protecting their work if they're just beginning? Does this happen regularly, that intellectual property is questioned, contract issues? Is it a very common thing?
Yeah, I think what's important, it is a common thing for sure. Mm-hmm. I think what people that are starting off need to realize, and they kind of need to weigh their options, that they're just starting out. Sure, they need the money, but a lot of work to hire contracts tend to be more for really customized applications, like for you know, a company that's come forward saying, we want to be the only one with this kind of app, or we want to be the only one with this type of website. So in that case, sure, you're giving up a lot of your IP rights. And I think that's where you have to kind of weigh, well, this is a one-of-a-kind situation. So do I really want to give up my IP to that, or do I feel that this is something that I could personally run with and market? But then you have to realize, if they have got you to sign an NDA, you can't release that information.
With it anyway.
Exactly.
Right.
So I would encourage, and by all means, I'm not an expert when it comes to making these types of business decisions, but you know, if you're just starting out and these are just basic things like, you know, IKEA or another company's like, look, we just need an app. We don't want to be, you know, the next Google. We just want a basic app.
Yes.
You know, I think in that case, as long as, you know, you've got your own open source stock, and you've also got your own libraries of code, you know, just make it clear to them, okay, I'm going to be using code that I've used before, and I'm creating something for you.
Because that happens a lot. You know, we have our libraries, we have our snippets that will drop little bits of code from here and there. So not everything will always be 100% organic code for each project.
Yeah, absolutely. I think in that situation, just making it clear to them that sure, you get rights to the final product as opposed to the 20 different snippets of code.
Yes. Yeah.
Yeah.
Yeah. And what about also another question with is it better to start out as contract work or working hourly, or do it as a full contract job?
I think it depends, and I unfortunately don't know the industry standard for this right now. I find that it tends to it's a bit of both.
Yes.
You know, people are gonna. I mean, every time I go to Waterloo, I always talk to guys who are like, "Hey, I'll do an app for $2,500."
Yeah.
And then you'll meet other guys that are like, "Well, you know what? I'm prepared to charge $50 an hour." I think essentially it comes around, it comes to be around the same amount of time.
And it could also be a little bit with that, I guess, with experience of how long you've been doing it.
Yeah, absolutely. How long you've been doing it for, and how I guess entitled you feel to charging that hourly rate.
Right.
But I think essentially what's important is, just really valuing yourself as a developer, and not overvaluing yourself, saying, "Hey, I'm a coder and I'm special," but just saying, I'm a coder, I'm in third year university, I don't have a degree yet, so what are my peers charging?
Yeah.
And at the same time, how special is the project?
Yeah.
I mean, is there a big time crunch? Like, do they want me to do this in 2 weeks? Right. Whereas normally it would have taken 2 months. And then you can charge, like, I'm not saying be dishonest, but you can charge premiums for these types of services, right? Yeah. So, just if they want to if you find that your client is extremely picky, and there's nothing wrong with that, but just letting them know, like, every time you're entitled to, like, I have a client, they're designers, they say, you know what, you're allowed 3 revisions, and that's it. So anything more than 3 revisions is going to cost you $100 per revision. Right. So, it kind of, you're charging a premium for your services, and then obviously you're not going to know this type of stuff until you start dealing with more clients. Yes. But really just valuing yourself and your time is important.
It's also a little bit of that, as you mentioned also too, like laying everything out clear in the beginning, what falls into the scope. Make sure it's laid out in your contract that, yes, you'll only get those 3 revisions. Anything after that, we charge extra. We offer this after that.
Yeah,
so,
absolutely. Being very clear with the project phases, the milestones, and, refusing to move forward until you've got their acceptance, their signature, and, payment.
Yeah. Good.
Yeah.
Well, Rosy, again, thank you so much for joining us tonight and giving us some legal basics for freelance designers and developers. It was our first webcast, so we are hoping to have more of them. If you would like to see more of them, please leave a comment on YouTube, contact us at FITC on Twitter, or email us at info@fitc.ca. A very large thank you also to HTML Toronto for being behind the scenes here with us tonight and bringing the webcast to you. And that's it. We will see you again soon. Rosy, thank you once again.
Thank you so much for having me here. I appreciate it. Thank you so much.
Thank you.